Hey guys, and welcome to today's video. Today, we have 5 different sovereign citizens in 5 different courtrooms. We have 3 returned sovereign citizens with several updates to cases I've already covered, an actual American national who thinks laws don't apply to him, and finally, a Karen who refuses to take part in her custody hearing at the cost of her children. So we have a lot to cover today. But before we begin, I'd like to thank today's sponsor, Aura. Did you know that AT&T recently revealed that over 73 million of their current and previous users' account data was leaked to the dark web? And about a month ago, Dell announced that they had a data breach affecting over 49 million of their users. Data brokers get their hands on this information and sell it to scammers, spammers, and anyone else looking to target you for nefarious reasons. And as more and more data gets leaked onto the dark web, these people's ability to socially engineer their way into your social media accounts, your bank accounts, or into your private lives gets easier and easier. And just to give you an example of how well Aura protects you against these bad actors, ever since setting up my account, Aura has already removed my information from 18 different websites, including People Search, People Finders, and AddressSearch.com. I didn't even know these websites were storing my information, but thanks to Aura.com, I'm not even worried about it. And if you think that one of these companies that you've trusted your information with has leaked that data onto the web, then you shouldn't worry either, because Aura's been kind enough to offer you a special discount along with a 14-day free trial for using my link Aura.com/Team Skeptic to sign up for an account. At $12 a month, that comes out to less than $150 a year for all the digital protection you'll ever need. So a special thank you to Aura.com for adding to my comfort level and sponsoring this video. Now we're going to start in Kansas with an update to a sovereign citizen that I covered 10 months ago.
Pardon?
Yes, I guess I'll represent myself.
Okay. You understand that if you can't afford to hire an attorney, one would be appointed for you.
I don't know what he would do for me.
You know, I caught quite a bit of flack for this video because there were viewers that thought that he was intrinsically stupid and I was just picking on the mentally disabled. Well, I'll have you know that I was right in assuming that his stupidity was all a ruse. I mean, don't get me wrong, he's still stupid, but he successfully negotiated probation as a punishment for several charges, including a level 5 drug felony. So let's begin.
Mr. Walker, you've been arrested for violating your probation with community corrections because it appears from the date you were sentenced, you may have never reported to them. You have a $10,000 cash or surety bond. Do you want the court to consider appointing an attorney for you?
Okay.
I don't know. They never noted on any of these docket sheets who your attorney was.
I don't have an attorney, ma'am.
He's never had one, Judge.
Huh?
He's
don't
never had one.
He entered a plea to a possession of methamphetamine, level 5 drug felony without an attorney. Is that what you're telling me?
Yep.
August 2nd.
Well, do you want an attorney now?
Well, I don't know. I don't know why I need one. I'm charged with probation violation.
Yes.
Is today a show cause?
No, it's
Oh,
to advise you of why you're here,
okay.
what your bond is, and give you a court date, an evidentiary hearing date, which is July 26th at 2:30.
Okay. Yeah, I don't know. I don't necessarily need an attorney.
Okay. All right. You have a
Okay.
bond. Go ahead and fill out a waiver of counsel, if you will, and put it in the, we'll file it in the file.
Yeah. But I'm not gonna sign anything though. I'm not gonna sign anything.
Well,
Yeah,
don't think the court can do anything with you if you don't waive counsel or have somebody appointed, one or the other.
I don't,
When is the last time that you worked?
about a year ago, maybe a little over a year ago.
All right, how old are you?
How old am I? I'm 60. Whenever they first brought me in here, that's the last time I worked. Whenever you all started arresting me for driving on a suspended.
Okay. Well, I'm
little over a year ago.
okay, so I'm gonna go ahead and appoint Jim Watts as standby counsel. If you don't want him, you don't have to use him, but he'll
Oh yeah, sure.
be around and be available for you, okay?
Yes, ma'am. I'll take counsel, no doubt.
All right, thank you, sir.
Okay, thank you.
Alright, so that's the first sovereign citizen out of the way. Basically, he negotiated himself a sweet plea deal, never showed up to probation so it got revoked, and now he potentially faces serving his sentence in jail. So now we head to our next hearing, involving one of the most asshole-ish sovereign citizens that I've ever covered, Albert Hicks.
All right, let's go with Albert Hicks. Albert Hicks. How he got on my docket, I don't know. This is the city of Detroit versus Albert Hemmer Hicks Jr. Appearance for the record, please.
Elwood S. Berry Jr. On behalf of the defendant, state your full name, Mr.
Albert Heimer Hicks, and no one is to speak on my behalf.
Okay.
I'm my own attorney.
Oh yeah? You're your own attorney? Well, that's cute. Why don't you go ahead and put your P number on the record then? Because if you don't have a P number, then you're not a licensed attorney in Michigan. Now you can represent yourself pro per or pro se, but you are not your own attorney because if you were, you would have already been sanctioned into retirement for all the bullshit you've pulled in court already.
You're your own attorney. You're an attorney registered by the state of Michigan.
Licensed to practice law, and you've been practicing law over the bench.
You say I have been?
Would you like to litigate against me?
I'm not litigating anything against you.
Okay, you have been practicing law across the bench since we started this. And I'm challenging jurisdiction today.
Okay. What do you want to do, Mr. Hicks? You want a trial date or you want the offer to send back?
I'm challenging jurisdiction.
Okay, put it in a motion.
I don't have to put it in the motion. I don't have to put it in the motion.
If I say you do, you do.
No, you don't have the right to do that. You don't have a Congress number. You don't have delegated authority to do that.
Okay. All right. Well,
I'm challenging jurisdiction.
Trial date. I'm denying. What is your motion? You're challenging my jurisdiction?
I'm challenging everybody's jurisdiction because you have none.
Okay, so
honor your oath of office, please. Honor your oath of office, okay?
Are we going to sit here and debate those positions?
It's not a debate. It's my constitutional right. It's my constitutional right.
You think so? Okay,
I know so. Are you violating my constitutional rights on how you deem them to be?
No, I'm not.
Okay.
I don't believe so.
And then please don't have me file for Title 18, 242.
Please do.
Okay, I have a transcript from all the other times I talked with you because you've been practicing across the bench for the longest.
Okay, so what are you going to do today, Mr. Hicks?
Challenge jurisdiction.
And how are you challenging that?
Because you have no jurisdiction. You have the burden of proof is on whoever assessed the jurisdiction. Who's the assessor of jurisdiction?
I am in this case.
Okay.
And I deny that motion.
Why you deny the motion? Because you don't have.
So Mr. Hicks, you're a grown man.
Citation needed.
Let's have a few seconds. Wait a minute. let's have a few second conversation, okay? Now
Okay.
let's get this straight. I'm running this show, okay? So if I'm gonna allow you to talk and say what you have to say, you're talking about challenging jurisdiction right now. That's what the discussion is. I say I have jurisdiction. The court rules say I have jurisdiction. The Constitution of the state of Michigan say I have jurisdiction. So I'm denying. No, don't talk while I'm talking. I'm denying your motion as far as you contesting my jurisdiction. Okay? So take your hood off, please. So other than that, what else do you want? How do you want to proceed now moving forward?
I motion to dismiss.
I'm denying that motion. Okay, let me ask you this. What basis are you denying the motion to dismiss?
Because no crime, a bill of attainder, no injured party. I told you all of this at the beginning, and you denied everything. You practice over the bench.
Okay, so now I'm going to give you two options.
As a matter of fact, hold on. Give me a minute. You even went through a 10 and 3 because you started threatening me. You remember that?
No, you were the one. Wait a minute. You were the one, Mr. Hicks, that said, "Oh, you can say all that while you're on the bench." That's what the court rules are. You gotta follow.
No, it's not. Then show me those rules. Let me see those rules. Send those rules to me.
I don't have to show you anything here. That's all public
Oh,
information.
you're acting tough now? You're acting tough now? Behind the bench?
Mr. Hicks. Let's not go there, all right? Did you say that last time?
Do you have the transcripts? Yeah, I said it. Yes, I did.
Yeah.
Yes,
yeah,
I did.
I thought about that.
I don't even have a
I
license
thought
to
about that.
law.
Listen, this whole.
You have license to practice law. Come on, the jig is up. The jig is up.
All right. So now the jig is up with you. So I'm not letting you say any more about this. I'm denying your motions. Now I'm going to give you two options. The first option is you can either take the deal that's in the file, or we can. Okay. Don't talk while I'm talking.
I tell you what.
Don't talk while I'm talking.
A few minutes. I got your paperwork ready. I got your paperwork ready. You really want to
talk?
You really want to do this?
All right. Now I'm going to give you one more time to interrupt me. If you interrupt me again, I'm going to hold you in contempt of court. Okay. All right. So the other option is we set a jury trial, and we'll set the jury trial. I'll give you motion dates where you can have the dates and you can put all of your stuff in writing that you want before the court. And I'll make a date on that date. I'll make a date when I'll rule on those motions. So do you want the offer or do you want the jury trial date and the motions dates?
I thought that the trial was up to me, whether I have a bench trial or a jury trial. It's not up to you.
No, it's not up to you. I'm giving you, everybody has a right to a jury trial.
Absolutely.
And I'm going to allow you to exercise that jury trial right. I'm not going to sit here and entertain a bench trial for you. Let a jury of your peers determine your innocence or guilt.
Why would I do that?
How?
I have the right to either or. You're not the one.
No, you don't have a right to. No, you don't have a right to either or.
Yes, I do. Of course I do.
No, you don't. You have a constitutionally protected right to a jury trial, not a protected right to choose between a jury trial or trial by judge. An actual attorney would know this. Now we're heading to the end of Judge Perkins' docket, where Mr. Hicks is about to reach the conclusion on these charges. And I mean just these charges.
All right. I'm moving on.
All right, move on.
You didn't answer my question, so I'm moving on. And I'm going to put you out. Or at least mute yourself. All right, let's do this and let's go back on the record one more time with Mr. Hicks.
For the record, Your Honor, Diachiku Mason, City of Detroit, 43471. This is the date and time set for a final pretrial in this matter. Your Honor, I did subpoena my officers to be here today for the final pretrial, and I do not see them here today.
Remove your hat, please. No drinking, please. Treat this like you're in the courthouse. Remove your hat, please, Mr. Hicks. All right, what are we gonna do? The officers were supposed to be here today. I'm only dealing with SP 1442547, counts 1, 2, and 3, SP 144-27651, and SP 5008721. I'm only dealing with those matters. And the officers are not here. So we're gonna make this easy. And now, what I don't appreciate is, you know, I thought about that comment that you made that last time, you know, basically, you're almost, it's almost like a little lightweight threat that you had toward me, saying that, oh, I'm only doing this, I'm only this way because I'm being protected by the bench. That's absolutely not. I'm the same way 24 hours a day. Okay, so let's get that straight. This robe has nothing to do with me as a man. All right, I'm gonna dismiss the cases because no officer appeared.
I would like to collect my costs and fees.
Pardon me?
I would like to collect my costs and fees for having to defend myself.
I don't want to hear anything else you have to say.
Oh, beautiful.
All right, bye.
So I know a lot of you are not going to be happy with this outcome, but hear me out for a second. I don't personally mind living in a system that requires such scrutiny for a guilty conviction, because in my opinion, a few guilty people slipping through the cracks of justice is way better for our society than having a bunch of innocent people locked up for nothing. But if there's anything you should already know about me, it's that I'm not gonna leave you hanging. So I have this clip for you from Judge King's courtroom, where Albert Hicks is before him on a DV case where he allegedly assaulted his partner of more than a decade and mother of his 2 children. Pay close attention to the look on his face as she testifies against him at his probable cause hearing.
Is that Albert Hicks?
Yes.
Okay, and how do you know that person?
He was my partner, and he is the father of my children.
Okay, how long were you guys partners for?
14 years.
Now this witness will show up. So even though Mr. Hicks may have beat his charges today, his days of free, unencumbered, and unlicensed travel in his road canoe are severely numbered. Next, we head to Washington, where we have an actual American national by birthright who incorrectly thinks laws don't apply to him.
My honor. So for the record, I've made this special visitation under duress pertaining to the matters of Jonathan Troy, Faifu Leaso Maliatoa Schuster. For I am beneficiary, I am sovereign, I am man, the flesh lives, the blood flows. I am a non-US citizen American national. I am sui juris imperfecta persona. I reserve all rights. I do not understand the status. And so I ask you, ma'am, what is your name? What is your nationality and what is your status?
I'm Judge Grant. I am a citizen and I'm the judge in this court. You are here subject to appropriate jurisdiction. So you are here for an arraignment. You've been charged with a crime. Today, you will be asked to enter a plea.
Ma'am, I object because a citizen cannot sit a bench, ma'am.
So I'm going to go through the information. It looks like you have been charged with driving with a suspended license, driving without a required ignition interlock device, refusal to comply not having proper registration on the vehicle, expired over 2 months. And then there was also a driving violation. Wheels were off the roadway. Last two are infractions. So
Ma'am, jurisdiction cannot be proven unless status is established. You have not established status. And so if you cannot do that, I challenge the jurisdiction. And if jurisdiction cannot be proven, I move to dismiss this case
That would be
with
denied.
prejudice.
that would be denied. So I am going to, at this time, review for probable cause.
Object. Again,
I
I
understand you object.
challenge the jurisdiction, and jurisdiction must be
But that is
proven.
not going to happen today. Today, you're
Jurisdiction
here
must be proven.
to hear the charges, and I will be reviewing for probable cause, and then we'll make a determination as to whether or not you will remain in custody. And I will hear from the prosecutor as to that.
And if you violate my rights even further, ma'am, as well as the officer and the sergeant that violated my rights, who are also going to be getting sued.
What's the deal with all these sovereign citizens taking the Chile de Castro route and threatening to sue judges and prosecutors? I've seen them threaten to sue their own court-appointed attorney just for showing up and putting their name on the record. It's gotten so bad that I recently caught a retired Michigan family court judge speaking on behalf of a state proposition that would protect judges and their families from undue harassment.
This is not personal to me. That these situations happen. I was a presiding judge of the family court for 8 years. These are conversations I have with my colleagues on a daily basis, talking about how sovereign citizens file UCC statements against us, against our property. We have to have lawyers in our court represent us to remove these filings against us.
So yeah, suing judges isn't gonna do anything good for your case, but it will screw you out of getting a PR bond and getting out of jail for free.
And the business, we call this foreshadowing.
It would just add to that. And I
You
don't
can do
think that
but
you
right
need,
now, I'm
you
gonna
need
have
to
you
go
stop
that route.
talking while I review this incident report. Okay, so this is authored by Brandon Carlsrud, signed under penalty of perjury. All right, I do find probable cause with the charges. I will be entering not guilty, please.
Ma'am, you cannot practice law from the bench. I object.
Noted.
You cannot enter a plea for somebody. That is, practicing bench from the
Unless you
law.
want to enter a plea of guilty, today there'll be a plea of not guilty. Understand you are objecting.
Ma'am, I
to-
object. I challenge the jurisdiction. Jurisdiction has not been proven. Status has not been proven or established. And once again, you haven't even established, your nationality or your status. I am a non-US citizen, American national by way of America Samoa. I reserve all my rights.
Is this something that we need to consider a competency evaluation for?
We may need to consider ordering ability to proceed, but
To question my competency because I'm evoking establishing status and asking you to prove jurisdiction is outrageous. And so, again, if jurisdiction cannot be proven, I move to dismiss this with prejudice based on the grounds that you cannot prove jurisdiction.
Jurisdiction is something that is both proven and established. It's established by Michigan statute and proven by a preponderance of the evidence at your trial. If you're challenging the court's jurisdiction based on the established facts, like time, date, or location, then you need to provide the evidence to support that claim.
all right, I've reviewed this. You were driving in the city of Lake Forest Park. You were violating.
Again,
the laws.
I was not driving. Again, I have rights.
You were
And
behind. the
my
wheel.
rights were
Your right was
violated.
traveling.
My rights were violated. My right to travel freely unencumbered was violated. There was no emergency in which the officer needed to put on his red and blue lights. And so, again, if status cannot be set, jurisdiction cannot be proven, I move to dismiss this matter with prejudice.
That's denied. So you've made your record. Right now, I'm going to directly appoint counsel from the bench. Ms. McDonald.
Again, I am
you.
sui juris in propria persona. I stand on my 2 feet. I'm in my proper person. And so
You're
I
saying
reserve
that,
all my
sir.
rights.
I understand that, and I've acknowledged that. I'm not dismissing your case today. I'm going to hear from Ms. McDonald as to the city's position on release.
Yes, Your Honor, I am going to be asking that the bail remain the same. It looks like it's currently set at $2,000. I do have some concern regarding his willingness and ability to reappear if he was released on his own recognizance, as well as concerned about community safety and risk of reoffending, given his temperament in the court today.
You expect me to believe that the risk of reoffending is higher with someone who doesn't think that laws and jurisdiction apply to them and threatens to sue the judge when she proves that they do? Okay.
And Your Honor, Mr. Schuster would ask the court to release him on his own recognizance. These are not violent offenses. I don't see that he has any convictions for violent offenses. There was an assault from 2021 that was dismissed. He may have a view of the law that is different than the city's, but that in itself does not indicate that he won't come to court or that he would in any way try to subvert court proceedings. So we'd ask the court to release him on standard conditions.
Well, the court can consider whether or not Mr. Schuster is likely to reappear for future court hearings. What I hear from him today is that he completely objects to this court having any jurisdiction. I don't have a good faith basis that Mr. Schuster will return if I were to release him. I do see that he has a prior conviction for DUI. He's on a deferred prosecution at this time in Seattle Municipal Court. He's not complying with conditions if he's driving without a license and driving without a required ignition interlock device. Also indication that Mr. Schuster will not abide the court's orders to appear on his promise. I want to look at the Seattle municipal case and see when he's next scheduled to appear.
Like he had mentioned too, in 2021, same situation, or not same situation, a situation occurred in which they tried to charge me. They didn't have jurisdiction. It was dismissed. And again, I don't want any charges against me because I do have the deferral, which would obviously violate that deferral. And so I will make any visitations, special visitations to the court to handle any matters pertaining to Jonathan Troy Faifale, also Malietoa Schuster. I'm a man, I'm free, and I want it to stay that way.
I do see it looks like he's got at least 3 prior warrants. He has 2 priors out of Benton County, 1 out of Lower Kittitas. The previous warrants history.
And throughout this process of going to courts, I've had to learn a lot.
Well, I guess we can count all those previous times that you were in court as missed opportunities because you didn't learn shit. You especially didn't learn that when you pled guilty to that previous charge that you're on deferral for, you actually proved to yourself that the courts do have jurisdiction over you.
And so I know it's no game to just not show and make visitations. That's not what I want to do. And again, jurisdiction does need to be proven, whether it's today or another date. And if you want to violate my rights even further by not releasing me on my own recognizance, ma'am, was it Jennifer Grant? Then, like I had mentioned earlier, you, along with the officer and sergeant, who are already going to be getting sued, I mean, there's no need to add you as well, especially when you know the law.
I don't see another date set until February 12th of 2025 in the Seattle case.
Seattle Municipal Court.
Yeah.
Well, Mr. Schuster, I have to do what I believe is appropriate in this case, and that is to set bail, and any threats to sue me or to take any action against me, I can't be swayed by that. So
Well, it's not a threat. It's just what it is. because my
absolutely, you
rights
can-
have been
you
violated,
can
and
do
if my
what you
rights
need
are
to
going to
do,
be
but
furthermore
you set
violated.
bail at $2,000. I do not believe that you will respond to the court's order to come back. I do base that upon the conduct in this case as well as the prior FTA history. So bail will be $2,000. If you're able to post bail, you are to return for your next court date. You are to have no criminal law violations. You're not to drive unless you have a valid license and insurance. And
When are you setting that court date, Miss?
is required by the Department of Licensing. You are, you will be represented because I'm going to assign counsel.
I am sui juris in propria persona. I present myself. I don't need to be represented by anybody. I stand on my own 2 feet.
Technically, you're sitting on your brain cushion.
These are criminal charges that have significant consequences for you. So it's in your best interest to have counsel.
Again, I
assist
stand
you.
on my own 2 feet. I do not need to be represented by anybody. I present myself sui juris in propria persona.
If you want to be your own counsel, you'll have to go through a full colloquy and waive all your rights to have representation. It's your constitutional right.
I
if
do
you-
not accept being represented by anybody. Again, I present myself. I am beneficiary. I am sovereign. I am an American national, a non-US citizen American national by way of America Samoa, like I had mentioned earlier. I reserve my rights and I do not need to be represented by anybody.
All right, the time for trial expiration is 8/9/24.
Again, if you are practicing law from the bench and putting a plea in for me, I object to that. You cannot practice law from the bench.
Next court date will be on June 24th. That's 2 weeks out.
So for the record, you have not established status, you have not proven jurisdiction, and you're denying my rights. Is that correct?
I don't know what you think would establish my status, but I do have status to sit in this court.
You are a US citizen. A US citizen cannot sit a bench. You're asking me to sign something that you pleaded for me. Is that
Yes,
correct?
I'm giving you notice of the conditions that I have set as well as bail.
You said,
I'm
yes,
noting
you
that I
pleaded for
found
me.
Probable cause. If you are able to post that bail and get out of custody, those are my expectations that you will come back on that court date and that you will abide by the conditions that I have imposed. Those are being ordered today. So that is what's happening today. And we are giving you that notice. You can refuse to sign that notice and we'll note that you were provided a copy in writing and that you refused to sign.
I do not understand.
Which part of it do you not understand that you have?
I do not understand how you can practice law from the bench.
I'm the judge and I am setting the conditions.
Well, you also entered a plea for me, correct?
What we're doing at arraignment is the plea is being entered. You're not pleading guilty. So on your behalf, I'm entering a not guilty plea.
So correct, you
cannot-
are pleading for me,
There's
correct?
2 pleas.
And if you
Not
plead for
guilty
me,
or
you're
guilty.
practicing law from the bench. You cannot practice law from the bench, so I object.
Right. I'm going to give you that piece of paper and we're done with your hearing today. We will see you in 2 weeks. Okay?
Jennifer
Okay.
Grant, you will be
Okay.
taken further.
Oh, poor guy. No one took him seriously and now he gets to go back to jail. So now we move on to our next hearing, which covers a well-known sovereign citizen on my channel and others, Eric Martin. And while he's normally in court over basic traffic citations, this time it's much more serious.
And then we've got Mr. Martin.
He claims to be an attorney, so he refused to speak with Mr. Fanbro.
I'm looking forward to it. All right, this is 241388, the state of Michigan versus Eric Joseph Martin. Sir, can you tell me your name?
Oh, not the Romans Desticate Trust, if that's what you're wondering.
Okay, are you going to tell me your name or not, Mr. Martin?
Well, I just want to make it clear, I'm not the legal fiction corporate entity defendant.
Okay. All right. Sir, if you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully participate in court proceedings, please let the court know immediately. You are here today on count 1, domestic violence. There's an allegation that on June 8th of 2024 in the city of Taylor at 9074 Clifford, that you did make an assault or an assault and battery upon Crystal Nicole Martin, a resident or former resident of your household, contrary to MCL 750.81 parent 2. This is a misdemeanor punishable by up to 93 days in jail and or $500. A consecutive sentence may be imposed under MCL 750.506A if the assault was committed in a place of confinement. Those are the charges against you. You've been brought to court on a misdemeanor charge, and you have the following basic rights: to plead guilty, not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered, and you may plead no contest with the permission of the court. You have the right to a trial by a jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, meaning you cannot afford to pay for an attorney. If the offense requires a minimum jail sentence, this charge does not have a minimum jail sentence. The court determines that it might sentence you to jail, and the appointing authority, which is the court, would decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of the appointed attorney, and you may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must then determine your ability to pay. Mr. Fanto, a court-appointed defense attorney, is present in the courtroom. It's my understanding he attempted to meet with you, and he was advised that you did not want to speak with him. Is that correct?
Because of the unfairness of the laws that would fraudulently assume if I take a lawyer that I would be giving up my right to be one of the sovereign people and be fraudulently assumed to be a legal fiction defendant. Yes, I
okay.
None of that made any sense. First, claiming that you're a sovereign is a consequence of your delusion. And second, if you take a court-appointed attorney, that doesn't mean you're no longer delusional. So you can both take an attorney and be a sovereign at the same time.
I have refused that a lawyer
Mr. Martin,
me.
if you have a trial, you have the following rights: to call witnesses to speak for you at trial, and you could get an order signed by the court to require those witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you will give up the rights that I just listed to you. You also have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty, or a finding of guilt is made by a judge or a jury, it may result in a violation of your probation or parole. The court can sentence you to jail and fines plus cost. And the court must tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, and both, which I've already done. Fines, costs, and other financial obligations imposed by the court must be paid at the time of assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, you can contact the court immediately and request a payment alternative. So those are your constitutional rights going forward, Mr. Martin.
I want to make it clear I have been illegally arrested here by barred away, okay, because he just went by her lies saying I kicked her. As soon as he walked through my door, I'm the one that called 911 on Crystal Martin, okay?
And what in irony's nutsack makes you think that the police have jurisdictional powers over your sister, but not you?
All right, sir, you have a constitutional right to remain silent, and anything you say with respect to this case could potentially be used against you in a court of law. So I would advise you at this time to remain silent with respect to the actual facts or allegations listed in the complaint and misdemeanor complaint, which I've read to you. Sir, are you gainfully employed?
Well, I wish to finish, before I answer your questions, I will answer your questions. I want to finish, exercise my First Amendment right, freedom of speech, and continue what I was saying. Now, again, I
Okay,
was
sir,
arrested
you are
illegally.
to appear in court as directed. I'm not going to argue with you, Mr. Martin. I understand your sovereign citizen argument. It's not the first time I've seen it or heard it. You are under the jurisdiction of this court. This court has jurisdiction under the Michigan Constitution and the laws of the state of Michigan. You are charged with a 93-day misdemeanor, sir. You've been advised of all of your rights. Okay, you have a First Amendment right, certainly, but you are here for an arraignment, not to lecture me on sovereign citizen beliefs, okay? I'm trying to get you through this and make sure you understand the process. You are to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You're to have no contact with the complainant, Crystal Martin, in this case. Do you understand me?
No, I do not understand, and that I do not stand under the charges, the false fraudulent charges, but I do comprehend. But as I was saying, I was illegally arrested in violation of my due process rights. There's not sufficient evidence for my arrest that I did any domestic violence. Bardaway just arrested me anyway. There's no video of me assaulting her. There's no, she did not see it. She just told a lie. I actually filed a PPO on her.
Sir, do you understand that you're not, to have no contact with Crystal Martin?
And then you need to tell her, do not come to my house. She keeps coming to my house so she can set me up with these lies because my sister
You're not
over. I have no, I don't want to contact her, but she
Okay,
needs to stop coming
sir,
over to my house. You know, I've been living there for
understand
36 years.
Miss Maudlin,
Let
that
me
will
finish
just
talking. I have the
go.
First Amendment right to
Unfortunately,
talk. I have the
Mr. Martin, it's clear to me at this point that you have no respect for the court. I believe that you're a danger. I can't get any information from you as to whether or not you have another place to reside, whether or not you understand the court's no contact provision. I need to know that you understand what I am telling you, because I am attempting to set a bond on your case. And if you want a bond on your case, you've waived your right to an attorney. And I'm trying to figure out, do you have another place to stay? Do you understand what no contact means? And if you're not going to express to me that you have an understanding of what I'm saying, and if we can't get on the same page about that, then I'm inclined to not give you a bond. Do you understand me, Mr. Martin?
I comprehend you, yes.
Okay, do you understand that I said you were to have no contact with Crystal Martin?
Yes, but she needs to stop coming over to my house. I'm not trying to contact her. She's coming over to my house and she can make false allegations like this, set me up so she can have the whole house to herself, her and my sister.
You know, you could have just said, "No, Your Honor, I have no idea what no contact means." And I wonder what kind of sovereign bullshit he tried to force on his ex and his sister to make them band together to keep him away from the rest of the family.
This is what the whole agenda is of her with my sister. Lisa Martin tried this before. Even though I proved to the court before the video of my sister Lisa Martin trying to set me up with lies and try swinging at me, assaulting me. I have this on video, saying with Crystal Martin here. I have her on video swinging at me and dealing with the prior case she tried to bring against me. Okay.
So
I have the evidence that she is aggressive towards me.
Mr. Martin, does Crystal Martin live at the home on Clifford Street?
Yes, she comes over like for a day or two, and my sister lets her come over, and she stays there for a day or two. Yes, and then here and there.
Okay, so your sister owns the home.
No, she doesn't own the home thing. So my understanding is the bank really owns it. It's always been like my parents' house. But I don't even think really my parents own it because they didn't finish paying off the mortgage or whatever. So I think technically it's the bank's house, but me and my brother and sister have been staying there for a long time. Me there for like 32 years. My parents have passed away now. So now it's like a fight with them two. They're trying to take over the whole house by coming with false allegations, by telling cops, "Oh, he assaulted me," all the time. There's no evidence. It's not true. It's a lie. There's insufficient evidence in violation of my due process rights. But Bardaway arrested me anyways, and this is just what she wants. So they can have the whole house to themselves. I even filed a Crystal Martin.
All right, so you're not to have
Crystal,
contact with Crystal Martin. You're not to return to 9074 Clipper in the city of Detroit, or in the city of Taylor, I'm sorry. You're allowed
Objection,
one
it violates
visit.
my due process. You
What's
cannot deny
that?
me my right to live at my house because of an unsupported allegation by her, which is a lie at that. Like I said, the cop had no sufficient evidence. She just told a lie, and the guy didn't even bark away, that is, the police officer, just came to me and arrested me right off the bat. That violates my due process rights if it's sufficient evidence.
Sir, you're allowed one visit to the premises to obtain personal belongings. You must be accompanied by a police officer.
And I want Barbaway. Well, hold on, I'm gonna let you finish. I'm just gonna say what I got to say, so you don't cut me off. And I want Barbaway arrested for his illegal arrest. I want Barbaway arrested for illegally arresting me. I want him charged for assault and battery, for illegally arresting me, and kidnapping.
Okay.
Because it was without my consent.
Mr. Martin, if you are not allowed at the 9074 Clipper Street address, where will you be staying?
I am allowed. I don't have nowhere else to live. That's my house. I'm allowed there. You ordering that is illegal. That violates my due process.
All right. He has a $2,000 cash bond with a GPS tether.
Yes,
And he's not to
violates my right to a
return.
personal bond.
He's
I have a
not
constitutional right
to appear at
he's
9.
innocent without guilty.
He cannot come to 9074 Clipper or be in contact with Crystal Martin.
All right, so that's the end of that hearing. And quite frankly, I'm tired of seeing this guy. He's a pretentious, monotonous moron, and he's exactly where he belongs. So now we're on to our last hearing, which is a sovereign citizen Karen involved in a custody battle, and she mistakenly believes that she runs the courtroom.
All right, now we're going to move to Habib versus Bouvier. All right, so remember when we last came on this matter, there were some issues that had come up that the court was not quite aware of. I think it may have been the reports. I had not yet read them. And some of the things that were being said, I wasn't familiar with. So I asked everybody to come back so that I can read through those reports and have a better understanding of the backgrounds of everybody. And so I've had a chance to.
Your Honor?
Oh, okay. Give me. So the court had an opportunity to review those and has a better understanding of background. I can't remember exactly how far we got in there. I don't know if Ms. Giles even made recommendations at that time. I don't think we got that far, but I'm not sure if you all remember or not. But I have read the recommendations in the report.
I don't think we got that far last time, Your Honor.
Okay, all right. So the let's see. So since I have that background, let me start by calling Ms. Giles. Raise your right hand. Please tell me swear or affirm testimony about to give in the case is the truth, the whole truth, and nothing but the truth to help you God.
I do.
All right, and if you would, we have Ms. Bouvier. Ms. Bouvier, you need to turn your video on because we're in the middle of middle of the hearing now. So you have to have your video on. You turn your mic off, but your video needs to be on.
Your Honor, for the record, before we proceed this matter, there are some facts I must state for the record. I'm here on special restricted appearance as the representative of the descendant. And I do not wish to waive any rights, rather statutorial or procedural. And for the record, as the authorized representative, executor, beneficiary, I have demanded a jury trial in regards to this matter. Moving forward, for the record, Your Honor, I have filed an amended notice of recusal with an affidavit of fact on May 29, 2024. With all due respect, Your Honor, I have not received a response from you in regards to this notice. Please note for the record, I have presented to this court on special restricted delivery all presentments to date. Moving forward, according to Georgia Code Section 1512-122 and 2020 Georgia Code Section 91138, rights to a jury trial is a reserved right.
Sure, but it's not considered a reserved right in a custody hearing. Those are exclusively held as bench trials in Georgia. And let's all just take a moment to enjoy the depravity of this Karen, who stares at the scales of value with her sovereign beliefs on one side and the custody of her children on the other, and values her beliefs more.
Please note for the record, at this time, I do not wish to add nor subtract anything from my presentments, and I stand behind my documents. And at this time, I respectfully excuse myself from this proceeding to await all notices concerning the trial by jury according to the law.
Okay, so first you filed a motion for recusal, which the court denied. Looks like you filed, you need to turn your video back on. If you don't turn your video back on, I'm gonna have a hearing without you. Okay, so turn your video back on. All right. You filed a motion for recusal, which the court reviewed and denied without there being sufficient evidence. I think you filed an amended one, which the court did not receive a copy of. You were supposed to send that to Chambers if you actually wanted me to respond to it. But you filed it via e-file. I'm noticing it now. It's going to be denied for the very same reasons. With regard to your request for for a trial, this is a custody matter. It cannot be a trial by jury because you can't have a trial by jury on a custody matter. So that issue will be denied. As for your representation, the court will consider you London Bouvier. That's who you are. That's what the court consider you as. If you want to consider yourself as anything else, that'll be up to you. But when I make a decision, it's going to be for your government name, London Bouvier. And that's what the law of Georgia is going to hold accountable. So when you don't do what I asked to do, your representative or whoever you think you might be won't be going to jail. It will be you, London Bouvier. Okay. So I want to make sure you understand that. So is that clear to you? All right. We're going to proceed in these proceedings. If you want to participate, that's up to you. If you don't want to participate, that's up to you. But I am going to make a ruling and the law will be what the law is. I suggest you should participate so that you can be heard and that the concerns that you have, the court will have an opportunity to hear them. That'll be up to you. Okay.
I really like the way the judge handles this situation. She gave Karen an opportunity to identify herself, and Karen chose not to. So just let the adult toddler know that you know exactly who she is and that the court will be proceeding despite her petulance.
Has this order been followed? Is it being
No, Your Honor, that's why we're here.
It's not being followed.
No.
No, right. We filed a contempt on this order on May 7th.
Really? I had thought that this matter was coming back on the calendar because I continued it from the last matter, but now I understand. Okay, so there is also the contempt on the interim order.
That's
all right.
correct, Your Honor.
Got it. I got it. All right. Yeah, all other issues shall remain. Okay. All right. So the order isn't being followed.
That's
It is
correct.
not.
That's the issue. It being followed at all, like no visitation or just being
No visitation at all, Judge.
all right, Ms. Bouvier, I've indicated to you once before that your video has to stay on. This will be my last warning to you. Turn your video on. Ms. Bouvier, if I say it again, I'm going to find you in contempt of court. If I say it again, I'm going to find you in contempt. So when any issue happens before, I'm going to have my deputies come get you. Okay. You turn it off again, I will find you in contempt of court. All right. So you will spend 10 days in the Cobb County Jail. You turn the video off again. Okay. Did you understand me, Ms. Bouvier? Did you understand me, Ms. Bouvier? Unmute yourself and say so. Ms. Bouvier, I'm going to ask you one more time. I'm going to excuse you from this hearing. I'm going to find you in contempt and I will pick you up. And your child will then go to Mr. Habib. Unmute.
I stand behind my documents. For the record, I stand behind my documents.
You can stand behind whatever you want. Do not unmute like I asked you. Ms. Marshall, go ahead and remove Ms. Bouvier from these proceedings.
Yes, ma'am.
I find you in contempt of court, 10 days in the Cobb County Jail. Child will be presented to Mr. Habib. these matters will be continued thereafter.
Well, look at Karen, finding the most efficient way to put 2 barriers up between her and her kids. 10 days in jail and temporary custody awarded to the father. I guess we'll see how this turns out when she's released from jail. Alright guys, that's the end of the video. It was long, but it was entertaining for me to make. And I'd actually love to know what you think about these longer format videos. So far, it seems as if you guys like them, but just let me know down below. And as far as the cases go today, I'll keep you posted on any new developments in future content. So if you liked the video, hit the like button. If you disliked it, hit the dislike. But don't forget to leave a comment below and subscribe with notifications on so you don't miss any of my content. I'm Team Skeptic, and I'm out.